Hi, my name is Goldman. I'm the director and founder of Goldman and Associates. Our firm has a primary focus on family law issues here in Michigan. And today we're continuing our video series, basically designed to educate the public and our viewing audience about significant issues relevant to family law. And today we're going to talk about divorce battles, particularly in high conflict custody cases involving the attorneys and the courts and how this works out. There are several causes for high conflict custody battles in divorces, and I think in our experience what we've seen is if the parties are really making an effort to prioritize the children and really trying to make sure that everything is done within their best interest, then you see a diminishment in the bitterness, and you see a diminishment in the litigation and the acrimony that causes that litigation, and that's a good thing. The problem is when people use the children to sort of jockey for position. When the kids are being used as sort of leverage to gain position in the divorce, when that happens, we tend to see that the battle becomes escalated, that there's embitterment. It reflects itself in a lot of motions before the court, a lot of hearings, elongated proceedings, and somebody may say, well, I'm going to try to get more time with the kids because if I do that and I succeed in that, that's all he cares about. So by taking away the kids, I build myself up leverage, that kind of thing. I'll get him to, give me the house so long as I agree to let him see the kids. So therefore, I'm going to leverage one against the other. When you see that kind of thing, that's where you get the divorces that really have a lot of embitterment in them, a lot of acrimony, and that's really, really not how these things should be handled. Really, the parties should figure out what they're doing with their kids. They should separate that as an issue. They should work together for the betterment of their kids, because you want to know something? If you're trying to get on the good side of your kids, one way to do it is not by horribilizing the other parent. That is never going to work. That's just going to put the kids in the middle. They're going to feel awful. You're going to give your kids all sorts of problems. So one of the keys to avoiding the high conflict is make sure that you're doing things in the best interest of the children. Lawyers will tend to utilize certain techniques to win custody battles. And one of the things they're going to look at is they're going to say, Judge, look what this parent is doing, putting the kids in the middle. And the other lawyers are going to exploit your efforts to maybe use the kids as leverage. So you're going to be very careful about that. So it's not only the wrong thing to do, it's something that the other lawyers are going to say, hey, they don't really care about the kids. They care about getting position with respect to the other assets. And that's the only reason why they're making a play for the custody of the kids. So you got to be very, very careful in that, because good lawyers will find ways to utilize what you're doing if it's not, what's the best way to say it, wholehearted, if it's not wholesome, if it's done for the purposes of doing one thing in order to accomplish a different goal, if there's a behind-the-scenes agenda. And when you're doing all this maneuvering that may be used against you, might not work anyway, think of the emotional scars that this leaves on the kids. Think of the emotional fallout, if you will, that's going to come across as a result of using the kids and trying to get the kids not because you truly want them, but because you're trying to jockey for position. I'll never forget, we had a case not long ago where a woman came to us and her husband was trying to take the kids, and we fought that guy off. There were multiple motions filed about this case and this kid. They did everything to try and take away the kids from this woman. They did every single thing that they could, and it resulted in 13 hearings, which we won every single one. We were 13-0 by the time those hearings came across. Ultimately, the case was settled. And here's how it was settled. It was settled without us. Because what happened was, after winning 13 in a row, the client came up to us and said, you know what? I appreciate everything you've done for me. You guys are fantastic. I couldn't recommend anybody else but you. You're the greatest. But you know what? I decided that at this point in time, I'm going to just leave things the way they are. Me and my ex are maybe going to try and work something out. And we said, great. And you know what I found out? She cut a deal. And after winning 13 battles in a row, she gave the kids to him in exchange for a house in Palm Beach. And that was what it was all about. So here we were fighting this battle for this person, taking the side, backing our client all the way, and winning, only to find out that the true agenda was an agenda that wasn't even told to us. It had nothing to do with us. So in a situation like this, we were kept out of that loop. People do that though. So you've got to be very, very careful that you're not doing that, and that the court doesn't think that your reason why you want your kids is because you're jockeying for position, because it's wrong, it damages the children, and it's fallout that nobody really wants to have to deal with at a later time. Now, if you have any questions about your case, of course, reach out. We'll be glad to help you out.